Dale, I have some follow-up from your story yesterday, Dale, because marijuana companies appeal the case challenging federal prohibition following district court dismissal, you guys. That's right. Major marijuana companies are officially appealing a federal court's recent ruling dismissing a case where they sought to block the government from enforcing prohibition against their in-state activities. That's right. Just 2 days after the U.S. District Court of the District of Massachusetts Western Division dismissed the case against the federal government, plaintiffs gave notice that they are appealing the ruling to the U.S. Court of Appeals for the First Circuit. The development doesn't come as a particular surprise, as plaintiffs had generally indicated that they expected the case to move up to higher courts. With the district's court's rejection of the suit, those wheels are now in motion, you guys. Even the district court judge had conceded that there are, in quotes, persuasive reasons for a re-examination, end quote, of the current scheduling of cannabis, while asserting that his hands were effectively tied by past U.S. Supreme Court precedent dictating the federal government's authority to regulate controlled substances even within state borders. To that end, Judge Mark G. Mastroianni, an Obama appointee, granted the Justice Department's motion to dismiss the case earlier this week. The actions came over a month after the district court held oral arguments in the case ahead of the hearing, and the judge had granted the marijuana firm's request to make the proceedings accessible to the public and press. The suit against the federal government, Canna Provisions versus Garland, was led by multi-state operator Verano Holdings and the Massachusetts-based cannabis business Canna Provisions and Wise Care Farm, along with Trevit CEO Grassi Sellers. Plaintiffs were represented by the law firms Boyes, Schiller, and Flexner LLP and Lesnar, Newman, Alio, and Nasser LLP. Litigator David Boyce, whose list of prior clients includes the Justice Department, former Vice President Al Gore, and plaintiffs in the case that led to the invalidation of California's ban on same-sex marriage. California's ban on same-sex marriage led the suit. In the latest filing, the plaintiffs said simply that they hereby appeal to the United States Court of Appeals for the First Circuit from the order granting defendants' motion to dismiss, which was entered in action on July 1st, 2024. At issue in the case is the degree to which in-state cannabis activities affect interstate commerce within the government, arguing that cannabis legalization attracts out-of-state tourists. DOJ argued in a filing in April that, in quotes, it is rational to conclude that the regulated marijuana industry in Massachusetts fuels a different kind of marijuana-related interstate commerce, marijuana tourism. In an additional quote, as the Supreme Court held decades ago, Congress has the authority to regulate businesses that cater to tourists from out of state, even if the business's transactions occur wholly in-state, DOJ said in the brief. Plaintiffs, meanwhile, contended that the Constitution's Commerce Clause should preclude DOJ from interfering in state legal activities because it's regulated within a state's borders. Even while dismissing the case, the court did rule that the plaintiffs have standing to bring it. In a quote, plaintiffs have alleged that variously engaged in the cultivation, manufacture, distribution, and possession of marijuana wholly in Massachusetts, and the CSA made such activity a federal crime, they said. Monday's order said, in a quote, in the absence of any dispute regarding redressability, the court finds plaintiffs have demonstrated that they have standing under Article 3 to challenge the portions of the CSA applicable to interstate activities related to marijuana. In an additional quote, the court also finds plaintiffs have shown there is a causal connection between their economic injuries and the CSA, the judge said. In an additional quote, when credited, plaintiffs detailed allegations about their financial injuries meet that burden, though individual decisions by specific third parties are the final link in the causal chain, and the economic injury actually flows from the multitude of similar decisions made by many third parties, all responding to the CSA. Nonetheless, the court sided with the government in its motion to dismiss based on a failure to state claim for relief. In a quote, given the scale of the plaintiff's operations, the court cannot find Congress lacks a rational basis for concluding plaintiff's activities subsequently affect interstate commerce without ignoring the Supreme Court's broadly wording holding in Gonzalez versus Raich, the court said. In that case, justices held that state marijuana laws do not protect people from federal prosecution because of Congress's interest in preventing illegal marijuana from entering interstate commerce. Josh Schiller, a lawyer on the case, called Monday's decision thoughtful and said that on appeal, we will continue to press our case that the federal government lacks any rational basis for banning state-regulated marijuana. At the same time that the marijuana industry stakeholders are experiencing the current legal setback, the Biden campaign has stepped up its push to draw a contrast between the president's marijuana policies at those of former President Donald Trump, stressing that cannabis is, in quotes, not as dangerous as we once believed, he says. On a new campaign page and buying ads promoting his clemency actions, the Biden campaign has repeatedly pointed to that action as an example of the marijuana policy disconnect between the two administrations. Man, oh man, I love how this article just ended with a whole bunch of gaslighting from Biden, but nonetheless, I do think that they are going to be ultimately successful in this argument, but time will tell and we shall see. And I can't wait to hear what Dale has to say about this. And this is Jason Beck for the High at 9 News. What do y'all have to say about this?
Well, this is what they expected. I think they set this case up to lose at the trial level. Mm-hmm. Good news is they found they have standing, because the courts are very quick to pull the rug if there's no standing. But everybody that uses cannabis is faced with the threat of the federal government. So standing up against that, I think, is a case of controversy which gives you standing. But those are legal technical issues. The big question here is, can we get a straightforward challenge to marijuana's inclusion in the CSA, and particularly Schedule 1, in front of the court? And if they do take it out, if they rule that it's unconstitutional to be there, and all bets are off about where cannabis is going to end up in the federal government structure.
Say that one more time, Dale. I'm sorry.
You got to follow the bouncing ball, Jason.
Yeah.
This is really deep legal stuff, man. This is thick stuff. This is a news show, my man. A news show. You can't act like a high chicken. You can't act like a high chicken. I know what that looks like.
I apologize.
Professor Chicken
Jason
Shits
is
has
producing
spoken.
the show as well as hosting today.
Yeah, so
you know, Adam is out of studio. He's helping, but Jason is trying to fix some kinks.
Yeah.
Jason's just
Having a Biden moment.
You know, I'll jump on Jason's tail as soon as I can, but I got to defend him on this one. You just stand out.
Ever since he started looks maxing, he's just a pretty face. I get it.
Wow.
Jason's glad to know what it's like to be a bad bitch, and he is taking all his pretty privileges, okay?
Wow.
For sure. I want to manage his Tinder account. The thing is that...
I got the OnlyFans. You got the Tinder.
Oh, no, I'm setting that up.
Anybody
All right.
Mm-hmm.
Yep.
The thing is that there was only a couple days between the ruling and their next move. So I believe this legal team knew exactly what they were doing. I don't think they ever intended to prevail in their first salvo. And to Dale's point, and I had said it a couple days ago, the fact that they were given standing is probably a huge victory in their minds as they march their way to the Supreme Court.
Mm-hmm. Yeah, I think they're ultimately going to win this case.
That we haven't had answered from anybody is, how far does the Commerce Clause go?
I think it goes.
Obamacare.
I was going to say, Dale, I think it goes 6,000 miles from coast to coast.
Well,
from sea to signing sea?
Yeah.
The problem is that I think this court is really ready to rule that we have this thing called the 10th Amendment, and the federal government can't invade that. And we don't apply the rational basis test to the invasion of 10th Amendment rights. That really is at the heart of all of this, because that's where Raich went. You know, we can go as far as we want as long as we can show it has the cumulative effects had some substantial impact on commerce. We have this specific amendment called the 10th Amendment. And if the feds aren't exercising this right, it belongs to the states. And that the states' rights issue has got a lot of people's panties in a knot, but it really is a place where the federal government has to be restricted, because the states are allowed to enact their own laws and be left alone by the federal government.
Yeah, but Dale, what do you think? I mean, I halfway feel that the state, the federal government has somewhat of a decent argument when they talk about regulating the tourism aspect of it, because all of these states that are close to one another, there's billboards saying, "Hey, come to this state to come buy our cannabis." Just like with Ohio, a lot of people are traveling to Michigan to buy their flowers, and a lot of states that don't have access, Nebraska, they travel into Colorado to buy their flower and whatnot, or even Oklahoma.
Yeah, Nebraska put up signs.
There's no doubt that the feds have grabbed that power, okay? And it's a commerce type of power. But one of the issues with the Commerce Clause that allowed them to go into interstate business was that you've got to have a very firm, steady federal position that restricts or prohibits all this activity, and that ship sailed a long time ago. Mm-hmm. So now they're looking for what? Tourists? The reason we're keeping marijuana in the schedule is because of tourism? That's fucking stupid.
It's a massive overreach.
I think it is too.
The Commerce Clause has been used to interpret things in a way that it's become this broad umbrella. I knew I had to go next when Dale said very firm, because that's who I am.
Oh boy.
But I
that's
think
his Tinder account, right?
Mm-hmm.
We do need to maintain some fluidity in potentially considering ways in which this more conservative court can roll back the way in which the Commerce Clause has been used to insert the federal government in things that arguably might not otherwise have their interference. To say that all tourism from state A to state B therefore gives the federal government the right to chime in seems a bit suspect when you think about it from a broader perspective.
Fair enough. This is going to be interesting to watch. I'm going to be paying very, very, very close attention. But seeing as how you guys are, you have any final thoughts on this, Matthew St. Germain?
I think the Commerce Clause is ridiculous. I think the feds need to just legalize all drugs. And I'm very disappointed in the Supreme Court, because they are just voting along Republican Party lines and disrespecting the Constitution. As much as I think the founding of this country is flawed, I think that the way that the founding fathers set it up was actually intelligent. And I'm just disappointed to see so many people operating without any actual intrinsic ethics or values. Mm-hmm. I wouldn't really mind, I harken back and miss the old Republicans, although they were definitely proto-fascists. At least they did have some sort of demonstrable, logical framework which they were trying to execute their dastardly white nationalist Christian plan through.
Jeez.
Mm-hmm. Fair enough. And on that, we're